most law firms are not going to have a recording on their law firm before they ever reach a person that says, do not say anything that is confidential to us, because that is the whole purpose of our engaging with the public. We are trying to gain information about prospective new clients so that we know whether or not they have a case, know whether or not we are going to represent them, can engage them for purposes of hiring us. And for purposes of legal ethics, we are treating them as a client, at least in terms of the confidentiality of the information, and making sure that that information remains confidential. And LSAs are shortcutting that. Hi, everybody, and welcome back to another episode of the Crushing Chaos with Law Firm Mentor podcast, where on today's episode, we are going to talk about local service ads and the grave risk they now pose to your law firm. So one of the things that has come up recently has been this topic of local service ads. And for those of you that are not familiar with them, they are a Google product, and local service ads have tended to get you the most qualified, most urgent buyers for your legal services. So most law firms in America now use Google or some form of online marketing. Google is not the only player in the market, but of course it is the biggest search engine. And so it's the one that we usually refer to. But, we're marketing online. And with that, there are particular concerns that we have to adhere to ensure that we are protecting our clients' confidential information. And we've all heard this. This is nothing new, right? But one of the things that is somewhat new is the fact that Google owns the product that it is allowing you to use when you use any form of its products, whether you use its search engines for, being found organically, or you use its pay-per-click ads. But most recently, there has been, and I say most recently, I'm talking about the last few years, there has been a rise in the use of local service ads. And so I want to talk to you today about local service ads because Google has made a sweeping change with the way that these are administered, and they present a major risk for law firms, particularly in the area of our ethics. So what has happened and what does it mean for your law firm? So I'm first going to tell you what's happened. It's an important key feature we have to talk about. But there are some ways that you can protect yourself and your potential clients and future clients that we're going to also talk about, right? So we're going to talk about the problem and some potential solutions. So first, the problem. Well, for those of you that haven't heard, Google is now giving itself essentially wide-ranging authority to access the call recordings from your local service ad calls and to be able to use that data as they choose. So you might be saying, well, how can they access the information? So for those of you that are not familiar with how local service ads work, essentially, if someone clicks on an ad that is tied to your account, then essentially they are routed to your law firm. And so it's the click to call, right? I click on the ad, I'm immediately on my mobile device able to call the law firm. Well, those calls are recorded. And typically, there has been a recording on it that says, these calls may be recorded for quality assurance, things like that. Well, the problem is most people that call a law firm want those calls to be private. They want to feel that they are, and they actually want to receive confidentiality. Because if I'm calling about a potential legal matter, I don't want anyone to have that information, to be able to use that information. I want that information to be preserved. So the little announcement, hey, your call is being recorded, oftentimes would simply stymie people from being able to stay on the phone. They would say, I don't want to do that, right? I'll call somewhere else where my call is not being recorded. So it's not been a requirement that you have to have that on there, but most lawyers who know that they are recording, especially if you are in a state that is a two-party state, meaning for purposes of the Wiretap Act, which is a federal law, some states are two-party states, some states are one-party state, right? If you are a two-party state, that means that you have to notify someone if you are recording a communication. If you're a one-party state, as long as you are a party to the communication, you are allowed to record it. So in some jurisdictions, you're not required to notify people that you're recording, but if you want to ensure that prospects know that the call is being recorded because local service ads were set up that way, you would place that recording, this call is being recorded on your line. And then ultimately people would sometimes they would stay on the lines and sometimes they wouldn't, right? There was a very high drop rate of those calls. So I'm not talking about that. Okay. That was a sticky enough widget for a lot of folks to say, I don't want to deal with local service ads because I don't want to scare away prospective new clients, especially folks who otherwise would have found you either organically or through pay-per-click ads and not have to have that same recording feature take place. Well, here is what is happening now, okay? What Google has decided to do with its local service ads is that call data is no longer going to be private at all, right? You don't have the option to not share that information with Google. Google owns the product, and Google, as a result, has decided that any and all calls that are placed on a local service ad are going to be essentially owned. The call recording is going to be owned by Google. You will have the right to use it for purposes of following up with leads, but the call itself is going to be, and the recording itself is going to be owned by Google. So now this went into effect June 5th of this year. We did get some notice of it. So there were some folks that knew about it before June. But for those of you that are hearing about it for the first time here, I'm telling you now, if you have local service ads, this is happening. And the difficulty is that it is a very wide sweeping authorization that Google has granted itself. It has the right to. I'm going to use this language directly from its notifications and its advertisements. The right to use, analyze, and repurpose all intake data, including call recordings, messages, and even URLs you share across your Google platforms. That includes your local service ad profile, content like logos, photos, service descriptions, pricing, and more. Now, that, of course, affects the prospective new client, but it also affects you as the law firm because your otherwise trademarked or copyrighted data, or if you have not trademarked or copyrighted your law firm logos, because many people haven't, certainly those markings and those identifications of your law firm can now be used for Google's purposes for whatever its purpose, right? It doesn't have any limitation on how that information can be used. But where it gets really scary is for prospective new clients, because a prospective new client is not given any type of notification that Google is going to own its messages, that person's call recordings, and that it can do with it what it will, right? Now, in theory, you would hope that Google would not take a prospective new client's call to your law firm that's been recorded and publicize it. But there is nothing at this point stopping one from doing that. Okay? Google has the right to do with that information as it will. And the other part of this is that it is extended usage. So that means it is forever and it's global. There is no automatic termination or expiration of that entitlement. That entitlement is into perpetuity. So that means effectively Google has a global perpetual license to use the firm materials and to use the prospective new client calls that come in on your LSA account. And here's the other thing. This is something that I think a lot of people have a little bit off on this. And I've heard some people talking about this. I want to make sure that we're clear on this. The fact that someone calls in on a LSA ad does not mean that they are truly a prospective new client, right? Because what many clients do, and I've had this happen in my own law firm, many clients don't remember your main number, right? We are past the time where people actually have to remember telephone numbers. A lot of times people get telephone numbers just by virtue of going on Google and searching. And so if someone goes in and says, hey, I'm a client of John Doe Law Firm, I need to get a hold of John Doe, they could go into Google and just put Doe Law Firm. And any number of things could come up, right? Doe Law Firm near me, or wherever they are located, right? A pin is going to drop on the map and the closest Doe law firm to them is most likely going to come up because of the nature of the service, right? It is very much mapped as a local service. And so when you search for that law firm, you might get a pay-per-click ad. You might get top of the, let's say Doe is really effective at search engine optimization and he or she, as John Doe, he sat the top of the search page, right? So you might get it there, but you also could get a local service ad. So that means your actual client could click on a local service ad. Now we hate when clients do that because they're technically spending money, for us to acquire them and they're already clients. But functionally, that does happen sometimes. And when that happens, those calls are recorded, right? There's no distinguishing between prospective client calls are recorded, but actual client calls are not. Whoever calls in on an LSA, whether it's a court, an adversary, or your existing client, if they're calling in on an LSA, on a local service ad, those calls are going to be recorded. The other thing is that Google plans to, and has been very clear about this, they plan to analyze this data. Now, how they're going to use what comes from the analysis is to be seen, right? They're not going to tell us that, because that could get into things like developing new products, that could get into selling new services, modifying existing services, etc. They're not telling us how they're going to use whatever the results are from their analysis, but their analysis is going to go into the acquisition and use of this information. And that's pretty scary, right? Now, I say pretty scary because for a lot of us, okay, and some of us more than others, right? Figure out where you fall on the spectrum here. But a lot of people are very concerned about the fact that if you are anywhere near a computer talking about anything, the next time you go on that computer to do anything on the internet, miraculously, your conversation has been heard or has been monitored in some way. And then ultimately what you are offered up shows up, right? Think about it. Any number of times I've had this personally happen, so I'll talk about my own experience, but I know many people have shared similar concerns about this. You go on Facebook and you're, chatting with a friend or checking up on, what's going on in your local neighborhood, or maybe there's a high school reunion coming up. So you're kind of checking out the details on that, right? And all of a sudden an ad pops up for something that you talked about over dinner last night that you were thinking about buying. Now, you haven't searched for it yet, right? You haven't taken some action. There's no cookie that's being dropped to follow you from a website that you've already visited. This is like just out of the blue, miraculously, right? Your desires are being fed to you. Now, when it's time for me to replace my refrigerator and all of a sudden refrigerator ads come up and there's a great sale at Home Depot, fine. But what happens when you're talking about something that's more personal in nature, right? So, this kind of spy economy, I think I've heard it referred to, has been a concern for a lot of folks. Well, Google is being very clear now that they are not being passive bystanders who happen to gain information. They are going to take any and all information that comes on their platform and they're going to use it as they see fit for their own profit, right? They are a for-profit company. There's nothing wrong with selling services and products for the purpose of profit, but it does intersect with your law firm and your prospective new clients. Now, here is the part that is the most dangerous part for you as a law firm owner. We as lawyers have a higher responsibility to maintain our clients' confidentiality than they have to maintain confidentiality, right? It is their entitlement. They can opt to share any and all things that they want to that comes out of an attorney-client relationship. We don't have that freedom. So when somebody calls a law firm, right, and then this is the case, I believe, in every jurisdiction, and if anyone knows of an exception or if it doesn't apply in your jurisdiction, by all means, let me know. But a prospective new client is treated as a client for purposes of seeking to engage a law firm, right? So Susie, the prospective new client, calls a law firm. She believes she is having an attorney-client privileged conversation, except in the extent to which you notify her to the contrary, right? So a lot of lawyers will say things, and they'll have it installed on their chatbots that are now very common on law firm websites. They'll have it installed on their messenger, like on Facebook and on Instagram, right? This is not an attorney-client privileged conversation. Do not put any information about your case here, as it is not protected by attorney-client confidentiality. But if I call a law firm, right, I am picking up the phone and I receive a message, welcome to the Smith Law Firm. As a prospective new client, someone who is designed or who is expecting a private conversation, how do I know that conversation is not private, right? Most law firms are not going to have a recording on their law firm before they ever reach a person that says, do not say anything that is confidential to us, because that is the whole purpose of our engaging with the public. We are trying to gain information about prospective new clients so that we know whether or not they have a case, know whether or not we are going to represent them, can engage them for purposes of hiring us. And for purposes of legal ethics, we are treating them as a client, at least in terms of the confidentiality of the information, and making sure that that information remains confidential, even if we ultimately don't have that person become a client of the firm. And LSAs are shortcutting that and essentially bypassing that, right? So if I were, prior to this rule that went into effect June 5th, if I were to contact a law firm, I am going to have some notification that my communication is not going to be confidential. But once I call, I expect that any and all things that I say to the law firm are going to be confidential. And the LSAs, according to Google's product terms and conditions now, are functionally saying, nope, you don't have the right to confidentiality, at least not where we're concerned. You can say whatever you want, and your lawyer or your future lawyer, potential future lawyer, may elect not to share that with anyone, but we're not agreeing to that, right? We're not being looped in to a lawyer's choice to maintain your confidentiality. We can do with your information what we will. But of course, the problem is that the prospective new client is not being told that. And for most prospective new clients, there are some very marketing savvy members of the public that engage lawyers, right? There are many that know far more than some lawyers do, right? But many, and I would say the vast majority of folks, do not. And that is why lawyers have a higher responsibility than a client does to ensure that their information remains confidential. So LSAs pose a huge risk for that information not being confidential. The other thing that we have to remember here is that Google is only giving itself one-sided control. So what does that mean? Well, Google gets expansive ownership and it gets usage rights, right? It also means that your firm is restricted. So it gets usage rights. You do not get usage rights. You are, by its terms and conditions now, if you use local service ads, only allowed to use the intake information for lead follow-up. And that's very specific in its terms and conditions now. So that means you lose the flexibility, transparency, and even possibly control over how you use the content. Now, again, you were already somewhat restricted in how you could use the content before because of attorney-client confidentiality. But if you and a client decided that you were going to waive that confidentiality in order to, in some way, protect the client or even secure the client, right? I've seen circumstances where there's a dispute about whether or not a law firm can ethically represent a client, and that dispute gets submitted to a court. And ultimately, a court has to decide if a wall, once upon a time is referred to as a Chinese wall. I don't think that is the most PC way to refer to it anymore. And I don't know what the replacement term is. So I'm just going to say a wall, right? A wall has to be erected between a person that could have a conflict and whomever is going to handle the case, so that the person that could have a conflict in a law firm, and this, by the way, it's very common to create these types of barriers in larger law firms where lawyers have moved around and could possibly have worked on the other side of any number of disputes that the law firm could handle. You essentially wall off access to, you don't give them access to electronic data, physical data, etc., in order to protect clients. Well, here's the thing. You might ultimately have to go to court if the other side raises a conflict and says, hey, my client previously communicated with attorney on the other side, and as a result, I want that attorney barred from representing the adverse party. If that dispute comes up, technically by these terms and conditions, you don't have the right to raise that information or share that information, share the initial call, what was shared in it, even if your client consents, because at this point, again, this information is owned by Google. The only right that you have by the terms and conditions is to follow up with a lead, and you're not following up once the person becomes a client. They're not a lead anymore. They're your actual client. So you lose a lot of autonomy there in ways that could ultimately restrict your ability to continue to represent the client. And of course, depending on the nature of the matter, that could be very expensive, a loss for your law firm. Finally, the thing that I think is really important to recognize is that by the terms and conditions with the new rules around LSAs, agencies may opt in their clients, okay? So it isn't just that you, the person who owns the account, right? So if John Doe Law Firm has an LSA account with Google, he may have delegated authority over all marketing of services for that account to his agency, right? The bestest ever marketing agency, right? So bestest ever could have gone in and accepted those terms and conditions on behalf of the law firm. And the most scrupulous of marketing agencies would be telling their clients, hey, here's what's going on with LSAs. You need to be aware of this. You need to specifically tell me whether or not you want to opt into this, because I need to know that I'm doing something that is your desire. But some not so diligent or not so scrupulous law firm marketing companies might just not say anything. Why? Some might be bad actors, some might be diligent and, still have a hiccup, and some of this might be negligent, but they might be thinking, hey, it's not that big of a deal, right? They might market for law firms, but not be owned by a lawyer, not know the particularities around it, not necessarily think that they need to notify their client. But however it happens, the agency can opt you in, and then you're stuck with those terms and conditions, and you might be still continuing to engage with the public as if these communications are confidential when, per the LSAs, they are not. But the fact that the agency opted you in does not nullify your consent, whether it was you directly or someone to whom you've delegated authority. It does not nullify the consent. Google has the information. It has a right to use that information. So I know I have now sounded the alarm about the LSAs, and you're probably thinking, oh my God, what do we do? Right? So there are some things we can do. I'm going to go over a couple of potential ways to work around this challenge. So the first thing you want to think about is you want to use your intake script to make sure that people understand the nature of the privilege that they have and that you are preserving the privilege. Okay. So that means you want to guide your own intake team to avoid discussing case-specific details or legal strategies on the phone. You don't want to have a person who came in through an LSA give all the details. Now, here's where the challenge presents with that, right? If you don't get enough information about the nature of the case, and as soon as the person says their name, they have, to a certain degree, given out otherwise protected information, right? In most jurisdictions, the identity of a client is still protected information, but you want to let them know as soon as possible not to give the details. So if you get details about a case that could identify a person, that could be something salacious that is in the news, or it could just be Susie Smith's divorce or John Doe's real estate closing, right? It doesn't have to be something of great magnitude to the world. It could be of great magnitude to the client and certainly whoever the adverse party might be. So you have to keep in mind that you want to give disclaimers so that people understand that confidential communications do require a formal engagement, right? Confidentiality does not start at this communication. It starts at engagement. Now, the challenge with that, of course, is that, again, that is going to scare many people. Many people would say, I don't want to do that. In fact, I remember when our law firm first learned about LSAs and we decided to try it as a strategy, we did place the recording on the line to say that this call would be recording. And we had an 87% drop rate, right? So just by putting this call may be recorded for quality assurance, right? A very significant number of people decided, nope, don't want to talk to you anymore, right? And I surmise, even though I don't know, I surmise that that would be a similar circumstance if you get on the phone with a prospective new client and say, hey, don't tell me any details because you're not going to have privilege until you get to the point where we are in a formal attorney-client relationship, okay? But that does protect you because at least you have done everything that you need to do to let that client know that they are functionally on a recorded line and that information is not, you're not able to protect it in the way you otherwise could. So that is not the most desirable of outcomes, right? How do we get to a more desirable outcome? Well, we've been talking about this and we've used this, we've talked about this necessity any number of times here on the Crushing Chaos with Law Firm Mentor podcast, and certainly in Law Firm Mentor, the company. We have talked about this with our clients and even with our prospective clients, but it is really, really important to get to first-party data, not third-party data, right? And what do we mean by that? That means that you want to get off of Google's platform and onto your own as soon as possible. So ideally, you have tracking set up on all of your calls, right? Many of our clients use CallRail. which is a system that allows the indigenous numbers that you assign to different marketing ads, right? You have an ad, you have a telephone number that's your main number, and then you have a certain telephone number that shows up when people from certain regions go to your website, a different telephone number for certain ads, a different telephone number for your local service ads, and so forth. The idea of that is that every time someone calls on one of those telephone numbers, your call rail system can tell you where that person came from. So you know the effectiveness of your ads, right? Super important that you do that level of tracking, because if you're spending $5,000 a month, I'm just going to use a flat number, on pay-per-click ads, and you see a big surge in new clients, you're like, oh, great, my ads are working. But if you're tracking, you might actually identify that maybe you had a big surge because you are doing a much more effective job of content marketing, right? Or maybe because you are doing better with your website. Maybe you are ranking higher with your website because you're making tweaks there. It might not be because of your ads at all. So you really need to know where people are coming from to know the economic effectiveness, the ROI of your ads. If you are tracking and you see that somebody comes from an LSA, you divert them, right? So instead of, hey, thank you for calling the Smith Law Firm, and I see that it's a local service ad, instead of going into or referring or transferring to my intake department and having someone in my intake department go through step by step of our intake script, where we're getting very detailed information. We're getting the name of the client. We're running conflict checks. We're getting the adverse party, right? We're getting details about the case. You want to get off of that line and onto a line that's not recorded, right? Because then you have gotten the lead. Now you have the ability to follow up with the lead, but simply by virtue of being on this line, Google doesn't have the ability to now tap your phone and get access to any and all phone calls you ever place, outbound or even inbound. They only have the ability to track the calls that come in on their local service ad line. So that is one way that very quickly you can divert people off of a line that is not protected by attorney-client privilege onto a line that is. And then finally, the last strategy I want to give you. Now, the second strategy is probably going to be the most effective for keeping you with local service ads if you choose to stay, right? I've told you about all the risks associated with them, but if you believe that it would be an effective strategy for your jurisdiction, of course, check the specifics about digital marketing, and most jurisdictions at this point have issued some form of advisory opinion or direct guidance around how you can use digital marketing because it is so pervasive. But if you believe that you're going to be safe creating this workaround, getting out of the otherwise not protected LSA line and into a protected communication line, way to go, right? But of course, I'm just going to, strong reminder, you need to check this yourself, right? Because we are certainly platform agnostic. We are state agnostic. We have clients in just about every state in the union. And it is still always going to be the law firm owner's affirmative responsibility to check for themselves whether or not they are in compliance with their state's legal ethics requirements. But here's a third strategy, and this is the one that is probably going to be the most fail-safe, and it is to diversify your lead channels and train your team accordingly. So we have talked about the need to have a diverse marketing array in your wheelhouse for quite some time. And this is, things like this, the terms and conditions of Google LSAs is like the perfect example, right? It shows us exactly why we must be very proactive in making sure that we are having opportunities to get clients through the door through a variety of different areas. And there might be some of you that are listening. We have several clients that hadn't gotten into digital marketing until recently, or if they're doing it as a very small piece of their total marketing mix. And most of their prospective new clients come from other places. And they're like, oh, well, I'm good because I get referrals, or I'm good because most of my leads come in through organic marketing. But you never know when there are going to be strategic changes, when there are going to be changes like this, changes to terms and conditions of a platform you're using, or where there's simply going to be market shift, right? Market shift happens all the time where Google is making changes and those changes are impacting your search rankings. They're impacting how people are finding you, what words are going to be effective for marketing versus others. And by the way, we have an episode coming up about some major changes that happened in the months of June and July that are currently affecting law firms, but that are also going to be affecting you going forward. But it's really important that you always have a diverse mix. And one of the things that I have always recommended is that you have no more than 30% of your business coming in through any channel. Because for most law firms, if you have a dip, even a precipitous decline in an area of marketing that's, let's say, 20, up to 30% of your marketing mix, it's going to hurt, but it's not going to kill you, right? But if you get 75% of your marketing through LSAs, through your leads through LSAs, then all of a sudden you can't use that platform anymore. Well, that's your business, right? So we want to make sure that we are giving you strategies to work around this major change to the LSAs, but also to keep in mind rule number one, which is diversify from day one. No matter what you are doing that's working well, I assure you at some point it will stop working and stop working in the way that you have set it up to work, right? There is no such thing as set it and forget it in a law firm. All right, everyone. Thank you for tuning in to this week's episode of the Crushing Chaos with Law Firm Mentor podcast. I'm Allison Williams, your host of the Crushing Chaos with Law Firm Mentor podcast, and I will see you on our next episode.